And good morning, my name is Konstantinos, and in this video we are going to see the Article 11 and Article 12 of the Federal Decree Law number 33 of 2021 regarding the relation of employment relations and its amendments of the United Arab Emirates. And the Article 11 is the Article 11 of the law identifies the following topic: an employer outsourcing some of its works to another employer, and Article 12 assigning the worker to another job. So, at first, Article 11. Article 11. Here we are. The Article 11 have only one clause, only one paragraph. The employer may outsource and assign the performance of any of its original works or part thereof to another employer, and the latter, this one here, the another employer, and the latter shall be solely liable in this case for the rights of his workers who are undertaking this work, which accrue to them in accordance with the provisions hereof, unless otherwise agreed by both parties. Let's continue. I believe it's crystal clear the meaning of Article 11. It says that in the case that a company outsource a part and agree, let's say, a percentage of the company workload to another company, then the contractor, let's say, the company that received the contract, in order for them to be able to implement the particular work or works, are solely liable for the rights of the workers that are going to undertake the particular work. And let's continue. I hope it's crystal clear. I tried to do my best to give an accurate description in the English language. Article 12, assigning the worker to another job. The worker, so Article 12 have 3 clauses or 3 paragraphs, 1, 2 and 3. Clause 1. The worker may not be assigned to undertake work that is fundamentally different from the work agreed upon in the employment contract, unless it is necessary in order to prevent the occurrence of an accident or to rectify the resulting damages, provided that the assignment is temporary and in accordance with what is specified in the implementing regulation hereof. I believe the hereof, the hereof, it is somehow confusing, and I am telling it because what from my point of view, what I try to figure out is that if the hereof means the entirety of the loan document, or if it means from Article 13 and onwards. So let's specify it. Okay, την εξόξω run to me Gemini. Let's ask Gemini, the AI agent of Google, what hereof means in a legal document. Whatever. In the legal documents, hereof is a pronominal adverb used to refer specifically to the document or section currently being read. Essentially, it is a legalese for of this document or of this matter. Common uses and meanings. The meaning changes slightly depending on the context of the sentence. For example, the provisions thereof, translation, the rules mentioned in this entire agreement. In section 5 hereof, translation, in section 5 of this specific document, the parties hereof, translation, the people or companies signing this contract. And why do lawyers use it? While it sounds old-fashioned, lawyers use hereof for precision. Using a simple word like it or this can sometimes be ambiguous. Hereof makes it explicitly clear that the writer is referring to the document as a whole, rather than a specific paragraph or an outside document mentioned earlier. Okay. Examples in context. Any breach hereof, any violation of this contract, subject to the terms hereof, depending on the rules in this document. The date hereof, the date of this agreement. Okay. No, not this one. Let's go back to the document. So anytime from now on, anytime we see the word hereof in the particular legal document, that means the entirety of the document. Okay, all the 58 pages that compose the particular loan document. So let me take a very, very short break, and then I will be right back. So again, let's read again the Article 12 of the assigning the worker to another job. Clause 1. So let's demystify, let's say, clause 1. The worker, that means the company employee, may not be assigned to undertake work that is fundamentally different from the work agreed upon in the employment contract. As obvious, the company employee again, the company employee will not be assigned a particular work from the employer, from the company that is different from the work mentioned in the employment contract. So if the worker contract mentioned that the worker should work as a data entry clerk, then the company is not allowed to assign a different work to the worker. For example, to carry logistics duties for the company, for the employer, unless it is necessary, in order to prevent the occurrence of an accident or to rectify the resulting damages, provided that the assignment is temporary and in accordance with what is specified in the implementing regulation hereof. So, but let's say there is a window in the law, in the regulation, that allows the employer to assign a worker temporarily different work than the one agreed upon the employment contract. For example, in order to prevent the occurrence of an accident or to rectify the resulting damages. Okay, as I understand, the worker, for example, may work as a data entry clerk, but may also have a certificate, let's say, a first aid certificate. So temporarily, the employer may assign temporarily the employer may assign the worker to different duties. For example, to be the first aid responder in the offices of the company, in the offices of the employer, and assign a different worker as a data entry clerk. And this will be a temporary assignment in order for the employer to prevent the occurrence of an accident or to rectify the resulting damages. Or might be that already an occurrence, or there might be an accident might be already an accident had taken place in the working space, and the particular worker was able to rectify the resulting damages. So the employer, from his side, chose temporarily to fully assign to the particular worker the duties, let's say, the work to be the first aid responder of the company. And the clause 1 concludes that, provided that the assignment is temporary, as mentioned earlier, and in accordance with what is specified in the implementing regulation hereof. And so the assignment have to be temporary, and have to be lawful under the articles mentioned in the particular document. I believe I was able to explain clearly the meaning of the clause 1. Let's move on. Clause 2. In cases other than those mentioned in clause 1 of this article, the employer, so clause 1 is paragraph 1. The article is Article 12, assigning the worker to another job. Again, in cases other than those mentioned in clause 1 of this article, the employer may assign the worker to undertake work not agreed upon in the employment contract, provided that the worker provides his consent in writing. And I believe this is crystal clear. Clause number 3, if the worker has to change his place of residence in order to be able to undertake work that is different from the work agreed upon in the employment contract, the employer shall bear all the financial cost arising therefrom, including the cost of the worker's relocation and residence. So it's like we see in Emirates. So they provide the option to the workers, to the Emirates cabin crew, to reside outside of the provided company accommodation. And in this occasion, the company provides a wealthy stipend per month, and in addition provides the necessary transportation from and to the working place. So in essence, what the clause 3 of Article 12 says is that, and I believe it's crystal clear from the meaning of clause 3 of Article 12, again, if the worker has to change, so my neighbors make noise and this disrupt my way of thinking. So again, clause 3, if the worker has to change his place of residence in order to be able to undertake work that is different from the work agreed upon in the employment contract, the employer shall bear all the financial cost arising therefrom, including the cost of the worker's relocation and residence. So my mistake. The previous example with the Emirates cabin crew was not a valid one. Was a wrongful example. Okay, for example, let's say in the initial example, the example of the worker that is able to provide first aid response to the workers of the company. Okay, so in the particular example, in order for the particular worker to be able to perform efficiently his duties, let's say, he needs to reside very close to the company offices. So this means he or she needs to relocate. So for the particular relocation of the particular worker, according to the United Arab Emirates labor law, the employer shall bear all the financial cost arising therefrom, including the cost of the worker's relocation and residence. So in the particular occasion, the employer will should be able to handle the entirety of the worker's relocation cost, and also the residence cost. That means the worker, my mistake. In such occasion, the company have to pay the monthly rent of the worker. The company have to pay for the relocation process. For example, for the relocation of furniture and for additional personal items of the worker from the initial, let's say, from the, from the last residential address to the new one. So any relocation cost, any residence cost, whatever this is, whatever this means, is upon the company, is upon the employer, not the worker. And this is Konstantinos. Thank you for watching the particular video, and see you on the next one. Have a nice day, have a nice holidays, Happy New Year 2026. Again, have a nice day and see you on the next video.